Hello, students. Let us begin a new act today, that is the Limited Liability Partnership Act 2008. Now, this act is nothing but a combination of partnership and the company form of business. So, if these two acts are thorough, I'm very sure that you will find that LLP is a very simple act. I totally agree that many students find this difficult because it is difficult to learn. It is very technical, and yes, you cannot write it in your own words. So that is why students are little concerned, and many of them, they leave this chapter in option. But I'm going to simplify it for you. I'm going to give you such beautiful handwritten notes that after we finish discussing this chapter, you will message and tell me, ma'am, you have made it so simple that we were worried about this act for no reason. I am sure that you are going to fall in love with this act because we are going to simplify it for you, and I'm going to give you handwritten notes which can easily be converted into sentence form. Okay, so don't worry about it. You're in good hands now. Let us begin the Limited Liability Partnership Act 2008. You will find that in my notes, I have first given you a list of the various section numbers which are important for exam. I've not covered every section number over here. There are 81 sections. Not all of them are important for exam. So the ones which are important are listed here. Don't leave any of these sections in option. Okay. So I have considered all that and I have given you a list of all the important section numbers. Please go through them and keep on reading them so that you are able to learn these section numbers. Uh, Imagine a situation, okay, imagine a situation where there is no LLP. See, whenever you start any particular act or a concept, you should understand why it is so important. Why do we need to study LLP? Don't we have partnership and a company form of business? What is the need for a limited liability partnership? Like when I also started my business, I had an option to either start a private company or a limited liability partnership or a partnership firm. I chose to do business in a company because taxation of a company is less. I am working in that kind of business wherein people prefer doing business with a company. Maybe I want foreign investors to invest in my business. So they will prefer interacting with an organization which has a lot of compliances and a lot of data is available publicly. So in my line of business, I found that company was more suitable for me. But there are so many other businesses wherein limited liability partnership or even a partnership firm can be a suitable form of organization. Now, if like this is my approach, whenever I start any new concept, I should first be convinced that yes, it is important. This is this has a lot of relevance in the business world. Only then I will want to study the Limited Liability Partnership Act. Yes, if I am convinced that LLP is not the right choice, I will, even if I force it, you will not be able to understand this chapter. So first, let us understand to whom is this type of organization suitable for. Now you will start working eventually, you will have your own practice, you will have your own clients. If they come to you with their business problems and tell you that you tell us which form of organization is suitable for my line of business, you should be able to judge and advise them accordingly, right? So study this from the practical point of view, don't study it just for exam point of view. What if you are faced with a situation and you need to list down the best features of these organizations and advise the client? See, this is the reason why I'm telling you that LLP or company or a partnership is suitable for you. So you should be able to convince that person. With that aim, my two friends X and Y, they want to start their business. Imagine a situation where there is no LLP. They have only two options: either do business in partnership form or company form. Then we will realize that what are the shortcomings of partnership, what are the shortcomings of company. Do we really need a combination limited liability partnership? So once we know the advantages, the disadvantages of both these organizations, only then we will be able to convince ourselves that LLP has the best features of both. LLP is a suitable vehicle for small businesses. So in order to convince us, because once we are convinced, we will be able to convince the client also. So in order to convince us, let us try to analyze and differentiate between both these organizations. Let us try to find the best features of both, combine it, and form an LLP. So LLP is nothing but it's a hybrid structure, having features, the best features of partnership as well as the company form of business. Okay. Now, Mr. X and Mr. Y, they are my friends. They want to start a business. Now they are confused as to the type of organization. So I'm advising them, and you also will help me. So we both have to advise them. So let's list the advantages of these organizations first. What is the main advantage of a partnership form of business? See, the main advantage is flexibility. And how does a partnership business offer this flexibility? It is through the partnership deed. See, Partnership Act is also very flexible. Now, the Act says you should not give interest on capital. But if it is mentioned in the deed, you will get interest. Acha, Act says no need to give salary, remuneration, commission. But we want to give. So mention it in the deed and you can give the partner salary, commission, etc. So Partnership Act is very flexible, and that flexibility is given through the partnership deed. Through this deed, you can have your own rights, mutual duties. The act does not force these duties upon you. Like, see, if you incorporate a company, you will have to compulsorily follow the memorandum and articles of association. I agree, you can frame your own memorandum and articles, but the Companies Act is very particular that no, all these points should be mentioned in your memorandum and you should ensure that the company follows it. But in partnership, there is a lot of flexibility. We are not imposing anything on you. You decide. You decide your rights, duties, etc. The second advantage which I feel is that registration is not compulsory. How is this an advantage? Last time we discussed that non-registration attracts a lot of disabilities. Ma'am, how are you saying that registration is not compulsory? How can that be an advantage? Now, because registration is not compulsory, people are not worried about an authority always after them or always keeping a check on them. Now see, if I tell you to incorporate a company, you will always have the fear that ROC, MCA, SEBI, there are other regulatory bodies who are watching me. So it becomes difficult for you to do business because you always feel that if I go wrong, I will be subject to a lot of penalties. Whereas in case of partnership, registration is not compulsory. If you get your even if you don't get your firm registered, you can still do business. Yeah, I agree that there are a lot of disabilities, but if you're ready to accept those disabilities, we are not going to stop you from doing business just because you are unregistered. But a company cannot under any circumstance do business unless it is registered. So a company actually comes into existence only upon registration with the ROC. So registration is compulsory. It is one of the most important requirements of a company, whereas in partnership, registration is not compulsory. Okay, let's not talk just about the advantages. Let us also discuss the disadvantage. Now, what are the disadvantages of doing business in a partnership firm? The biggest disadvantage which I can see is unlimited liability. In case of partnership business, my liability is joint, several, unlimited. What is the meaning of joint? Joint means we are jointly liable. Together we are liable. Okay, we are liable together. What is the meaning of several liability? We are also individually liable. And what is the meaning of unlimited? It means my personal assets are also liable. It means in case of a partnership form of business, I am always at the risk of losing my personal assets. My personal assets are also liable. So if the business assets are insufficient to pay off the business debts, then I will have to make arrangements from my personal assets. So there is always a risk of losing my personal assets. Liability is joint and several. It means I'm liable not only for my share, but also for the share of other partners. Now imagine your partner has purchased goods worth rupees 5 lakhs. He spent that money, he sold the goods, he spent that money. The customer, or the supplier can recover that money from the firm, that is from the other partners. So you are responsible not only for your acts but also for the acts of other partners. So that is one of the most, I think, that is one of the biggest disadvantage of a partnership business. Also, there is no separate legal status. Whatever belongs to me belongs to the firm, whatever belongs to the firm belongs to me. So there is no separate legal status. There is no separate legal status. The partner will be liable for acts of the other partners. Now, what happens in case of company? The company is liable for its liabilities. The assets are also owned by the company. There is separate legal status. The assets of the company belong to the company only, not members. But here, assets of the partnership belong to the partners. Partners personal assets may also be used for paying off the debts of the company. So actually, there is no boundary, there is no separate legal status. Whatever is the partners, whatever belongs to the partner belongs to the firm, whatever belongs to the firm belongs to the partner. What if the firm is not able to pay its debts? You can recover that from the partners. So the debts of the firm are debts of the partners as well. There is no separate legal status. Can I also say that this is the concept of mutual agency, that I can bind the others by my act, I can bind the other partners, I can bind the firm. Mutual agency. What is the concept of mutual agency? Mutual agency means that I am liable for the act of other partners, and they are also liable for my acts. There is principal agency relation. Now, X, Y, Z, they are three partners. X purchased goods worth rupees 10,000 from A. What if X is not able to pay? Can I recover that money from Y and Z? Yes. As an agent, okay, as an agent, X can bind the other partners. What if Z takes loan of rupees 1,000 from B? What if Z is not able to repay? Or he used it for the firm only. But what if he is not able to repay? Can I recover it from X and Y? Yes. X is bound as a principal. So, as a principal, he is bound by the act of other partners. So, I can bind, but I am also bound. This does not happen in case of a company. I am not liable for acts of the company. The company is not liable for my acts. One member is not liable for the act of the other members. Other members are not liable for my act. There is no mutual agency in case of a company. But yes, in case of partnership, I am liable not only for my acts but also for the act of the others. That is one of the disadvantage. The another uh, disadvantage. Okay, there is fourth, right? Another disadvantage is that there is no perpetual succession. You must be wondering, ma'am, you are writing the disadvantages of a partnership, but these are all advantages of a company. That is how these two type of organizations differ, no, from each other. One's advantages are the other's disadvantages, and that is why this helps us to choose between the organization. What is that you require? You choose an organization which will provide you those features. So there is no perpetual succession. No perpetual succession means it is affected by death, insolvency, insanity of a partner. X, Y, Z, they are partners. X died. Yeah, we may agree that the firm will not be dissolved, but if there is no such agreement, then yes, there is dissolution of partnership. There is dissolution, right? You are affected. So I think that these are all the disadvantages of a partnership business. And these are the advantages of a company, yes or no? So let us also highlight the advantages of a company. The first, and I would say the biggest advantage of a company, is limited liability. Now, what is limited liability? X purchased 10,000 shares of face value 10. Okay, he purchased 10,000 shares of face value 10. But the company has called up only 6 rupees because they need only 6 rupees right now. So on 10,000 shares, he has paid 6 rupees. It means he has paid 60 rupees, 60,000 rupees. And he has purchased shares of 1 lakh. Now from 1 lakh, he has paid 6 rupees. That is, on 10,000 shares, come to 60,000 rupees. So he is now liable only for 40,000 rupees. He has already paid 60,000. He is now liable only for 40,000 rupees. This is nothing but limited liability, that my liability is limited only to the amount unpaid on shares. You can also say that your liability is restricted to the face value of shares. You will under no circumstance be liable to pay more than the face value. So you are under no circumstance required to pay more than 10 rupees. That is the meaning of limited liability. So there is no risk of my personal assets being used for the business. I think this is one of the very good advantages of a company. I have no fear of losing my personal assets. If the company is not able to pay off its liabilities, members will pay for only the unpaid amount. Rest, the company has to make arrangements, or it will be considered as bad debts. The company will go bankrupt. The next advantage is separate legal status. Company enjoys a separate legal status. Company is an entity which is separate from the members. Now, separate legal status means that the company has its own assets, company has its own liabilities. Now, the company took loan of 5 crores from the bank. Now, if the company has taken 5 crore loan from the bank, the company will be liable to repay it. They cannot tell the members, "Are listen, members, we don't have 5 crores. Huh? See, the company is yours only. No, you are the owner. You now contribute thousand rupees each, and then we will accumulate and pay 5 crore rupees to the bank." Sorry, your liability is yours only. You cannot claim it from the members. Once the members give you the share money, they give you share capital, that money now belongs to the company. If you buy assets from that company, those assets belong to the company, not members. See, once you give money to the company is free to use it as they like. The assets purchased from that money now belongs to the company. The liabilities of the company belong to the company. Members are not liable. Similarly, member took loan of 10 lakh rupees for daughter's marriage. Now the member is not able to repay. Can the member say, "Company, why don't you help me? I am your owner. I will repay this money to you later"? Sorry, you are not liable for the liabilities of the company. Similarly, company is also not liable to pay off your liabilities. This is separate legal status. Assets of the company belong to the company. The liability of the company is also that of the company. Members and company, they are two separate persons in the eyes of law. Members can enter into contract with a company, but in this case, partnership, there's no separate legal status. Partners cannot contract with the partnership. They are not two separate persons in the eyes of law. They are one and the same. Next, we have perpetual succession. I hope you are writing along with me, or you plan to write this later. It is going to help you a lot when you sit to revise this chapter. Perpetual succession: members may come, members may go. The company's existence continues till it is wound up. See, company is an artificial person in the eyes of law. We incorporate a company, okay? It is an artificial person in the eyes of law. You have to create, you have to incorporate. It doesn't take birth like a natural person. Just like it doesn't take birth like a natural person, it does not die a natural death. You have to dissolve, or in other words, you have to wind up the company. So perpetual succession means that the company continues to exist till it is wound up. But what happens in case of death? What happens in case of death of a member? The company status is not affected, no? In case of death, the shares will be transmitted to the legal representative. In case of insanity, they will be transmitted to the guardian. In case of insolvency, they will go to the official receiver or assignee. So at any given point of time, you will have people who are holding the shares of the company. So this is also one of the advantages of a company. And now let us discuss the disadvantages. One disadvantage which I think is a deterrent, like, this is the reason why people don't incorporate a company, is that it is governed by rules, regulations. There are various acts applicable to it, there are various regulatory authorities. They are constantly keeping a watch on you, they are constantly monitoring whether you have filed the necessary documents or not. So you have ROC, you have MCA, you have SEBI, etc. SEBI in case of listed companies. So there are so many regulatory authorities. There is no flexibility at all. You cannot run the company the way you like. You are bound by the Companies Act, you are bound by the laws of SEBI in case you are listed. You are also bound by the memorandum, articles of association. You cannot make changes the way you like. You need to pass a resolution. There are so many compliance requirements. So, because of these disadvantages, people may not want to start business in the company form. Now, do one thing, students. From all these advantages and disadvantages, choose the best points. Now, let's say that I give you a business, or a form of organization which will provide a lot of flexibility. What if I say that there is a form of organization which will give you limited liability? There is an organization giving you separate legal status, perpetual succession. There are very little, or there are manageable regulations, compliances. We give you a lot of flexibility to frame your own deed, to have your own mutual rights and duties. There are less legal requirements. What if I say, let us combine the best features of these two type of organizations? Would you like to do business in that type? Of course, yes, ma'am. What is it known as? That is known as the limited liability partnership. Limited liability partnership offers a lot of flexibility in the form of giving the LLP authority to frame their own deed, the mutual rights, duties of the partners and LLP, that can be framed by their own deed, which they will draft themselves. So there is no memorandum or articles which is imposed on LLP. They have a lot of flexibility in doing business. Okay. What if I say that this type of business will have limited liability? Your personal assets will not be liable. So there is no fear of you losing your personal assets. We will give you perpetual succession. You will not be dissolved. We will also offer you separate legal status. So you need not worry about the debts of the company. Debts of the company belong to the company only. What if we combine the advantages of both these organizations? Then what you get is LLP. I think this is one of the best forms of organization in today's time. You will very soon start articleship. Please notice that the traditional partnership firms, okay, the traditional partnership firms have now, most of them, they have now converted to LLP. Why? If there are, let's say, 6 partners, partner C was accused of some fraud or some malpractice in one of the audits, and he was subject to a penalty of 10 lakh rupees. Now he doesn't have 10 lakh rupees. The firm, that is the other partners, will have to bear that penalty, because we are liable not only for our actions, but we are also liable for actions of the other partners. Why should the other partners bear C's liability? So there was always a risk in the traditional form of partnership. That is why most of them, to get the benefit of limited liability, okay, to get the benefit of limited liability, they have now converted into LLP. Also, when a partner would retire, there are so many cases where nowadays there is a lot of attrition. People come, people go. So again and again, you had to keep on revising the partnership deed, because yes, you dissolve the firm, then again a new partner is admitted. So because of the movement in labor, they were facing a lot of problems. So now we say, no, LLP is now giving you perpetual succession. There's no dissolution if a partner leaves, new partner is admitted. So you need not follow that procedure of dissolution every time such kind of a change happens. So, because there were a lot of advantages in LLP, many partnership firms have now converted into LLP. There are so many private companies which have converted to LLP. There was a time when even I was thinking of converting my partnership firm into LLP, because there are a lot of compliances. You have to maintain the books in a certain manner, you have to get them audited, then you have to file your annual return, you have to file so many other documents, you have to always pass a resolution, etc. So there are many compliances, and if we don't have time for all that, then LLP is a very good option for us. But yes, I have not yet converted. That is another story. But very soon I intend to do that. Okay, but yeah, in case of company form, the taxability is slightly different from LLP. So you have to see how your business is taxed, and accordingly, you have to give your advice. You have to give advice to the client that considering the various factors, this type of organization is suitable for you. Let us read something about LLP. Limited liability partnership is an incorporated partnership. I love this sentence. LLP is an incorporated partnership. These two words clearly indicate that LLP is a combination of a company as well as partnership form of business. This is a partnership which is incorporated. Incorporated means it is given a separate status. Are you getting me? It is a body corporate. It is a separate legal body clothed with legal personality. Body means you are giving it clothing and making it a separate person in the eyes of law. This is not just a partnership, it's an incorporated partnership, which simply indicates that this kind of a business has separate legal status. Because you are incorporating it by the operation of law, it can be brought to an end also by operation of law. So this also indicates that there is perpetual succession, because you have to wind it up by operation of, it will not die a natural death. It will not even be affected by the members who die, or the partners who die. It is not going to be affected by death, insolvency, insanity of a partner. It will continue till it is wound up. See, it is incorporated by the operation of law, so it will be dissolved also by the operation of law. So it is an incorporated partnership which is formed and registered under the Limited Liability Partnership Act 2008 with limited liability and perpetual succession. Because it is incorporated, it has all the features of a company: limited liability, perpetual succession. Yes. Now, the Limited Liability Partnership Act reads as 2008. But you will be surprised to know that the act actually came into force on 31st March 2009. The act is the LLP Act 2008, but it came into force from 31st March 2009. So let's go through the timeline, which will help you to understand when was this act enacted, when did it receive the approval from the parliament, and when was it notified in the official gazette, and what was mentioned. So through this timeline, you will also come to know the various dates. Okay. Now, LLP, you can write along with me. Okay, I'm going slow. LLP was enacted by, just draw a column. No, I will need two columns. Okay, LLP was enacted by Now, who is the law making authority in our country? Parliament. Yes, so it was enacted by the Parliament of India. Parliament is the law making authority. So, LLP is an act of Parliament. Now, do you remember we had discussed that in order to make an act, you first prepare a draft. See, whenever you are asked to prepare some report or some project in the college, you don't start preparing everything as if it is the final piece of submission. You first make a draft. Yes. So, or you draw an outline, then there are deliberations, discussion. Similarly, the act also follows the same procedure. The draft stage is known as the bill. So, bill is nothing but a draft which is first placed before one of the houses of parliament. So, let's say that the bill was placed before the Lok Sabha. So, there were a lot of discussions, deliberations, debate. It was passed by the Lok Sabha. Then it went through the Rajya Sabha. Again, it was presented. There were debates around it, discussions. It was also passed by the Rajya Sabha. Once the bill is approved by both the houses of parliament, then it is sent for the president's approval. So, in this case, the bill was passed by the parliament on, you can write it. Bill was passed by the parliament on. Now, even though we are writing that the bill was passed by the parliament on, we actually mean that it was approved by both the houses of parliament. So both the houses, they gave their approval on 12th of December 2008. Now the houses have given their approval, but we also need to receive the consent of the president. So the president's consent was received on 7th of January 2009. So you can write over here, the assent of president was received on, okay, 7th of January 2009. Once it is approved by the president, you cannot say, "Arey, congratulations, the act has come into force." Did you inform the general public about it? How will they come to know that an act has come into force? Inform them. This public announcement is made through the official gazette. So the notification was published in the official gazette. This is a booklet for public announcement. Okay, now this official gazette is actually a public announcement that the act has come into force. Now, this was on 9th of January 2009. In this notification itself, they had mentioned that the act will come into force on, act shall come into force on 31st of March 2009. It is possible. It is possible that only the first section comes into force on the day it was published in the official gazette, but the official gazette mentions that the act will come into force on 31st of March. Then the act comes into force on the day which is specified in the act or in that official gazette public the notification. So students, this is the timeline. This is how the act came into force through various stages. Yes, the act has come into force. The limited liability partnership is an organization which can be formed. But who are the administrators of the LLP Act? Who actually govern the LLPs? So you can also write administrators of LLP Act. So who actually makes amendments? Who keeps a check on the incorporation of LLP, running of existing LLPs? So the administrators are the Ministry of Corporate Affairs and ROC. This is Registrar of Companies. What is ROC doing here? See, in partnership firm, you had Registrar of Firms, but LLP, companies, they are all under the rule of ROCs. They are all governed by ROCs. Now, registrar of companies, they help in the incorporation of LLP and also the running of existing LLPs. MCA, Ministry of Corporate Affairs, you can write it over here. Okay. So MCA and ROC very similar to the company. There is one provision in the LLP Act which, after you read it, you will understand that why it is administered by MCA and ROC. See, the LLP Act currently has 81 sections, but it is not possible for us to, include everything in these 81 sections because there is so much of similarity between LLP and company form of business. There's a lot of similarity. Now, the Companies Act has 470 sections. Yes, the Companies Act has 470 sections. Now, it is not possible for us to replicate everything in this LLP, right? So, what we have done is, to the best of our ability, we have tried to make all the provisions for LLP. But law says that sometimes there are certain words or there are terms which are not explained in the LLP Act. The meaning of those terms, phrases, words can be taken from the Companies Act. If there is nothing mentioned in the LLP Act, if you need a provision, then that can be used from the Companies Act. Okay, so if certain terms are not explained, if there are certain words which are not very clear, you can use the same meaning as given under the Companies Act. If you are stuck, I don't know what to do now, how to proceed, what is the procedure, follow the same procedure as given in the Companies Act. So yes, we can say indirectly that wherever you get stuck, refer the Companies Act. The central government, okay, central government has been given the authority to frame laws, rules, and to make amendments in those laws and rules for LLP. So, who is the authority making these laws for LLP, making the rules for LLP? It's the central government. So, the central government has the authority to make laws, rules, etc. for LLP, and also to make suitable amendments in them. Okay, so the authority has been given to the central government. Okay, I hope you wrote this. The act has been enacted to make provisions for the formation, regulation of LLP, and for the matters connected and incidental thereto. This is the preamble or the long title. It's the same. Okay, this is the long title. It actually describes the scope, the purpose, the object of LLP. So what is the scope of LLP? The LLP Act, okay, LLP Act, it covers only limited liability partnership. Will the partnership be governed by this act? No. The scope of the act covers only and only LLPs. What is the object of the act? What is the purpose of the act? The objective or the purpose of the act is to give provisions for the formation, for the incorporation, and for the regulation, for the functioning of LLP. So, why was this act enacted? Because we wanted to give provisions for the formation and the regulation of LLP. So, what is the scope of this act? To what type of business does this act apply? It applies only to LLPs. And what is the purpose of this act? To give the provision for formation and regulation of LLP. So, this is the preamble. Preamble is scope, object, purpose of the act. This is the preamble. This is the long title of LLP. LLP is a body corporate. It is a person separate and distinct from its partners. LLP provides benefits of limited liability, but it also allows members the flexibility. They can frame their own internal structure through a mutually arrived arrangement. This is nothing but the deed. Okay, or you can also say this is nothing but a partnership agreement. So you can frame your own partnership agreement. You can decide your own mutual rights, duties, etc. Ma'am, these partners are very lazy. They don't have their deed. So what should we do? Do you remember in the Companies Act, I had discussed that if you don't have your memorandum and articles ready, the model memorandum and articles in Schedule 1 will apply. Similarly, here also, if you're not ready with your partnership deed, then the first schedule shall apply. I will show you what is written in the first schedule. Now, what are these schedules? See, we cannot write everything in the act. Act becomes very bulky. There are certain procedures. There are, like in this case, conversion procedure. There are certain formats, like I want to know how to prepare the P&L of this LLP. So in order to mention instead of mentioning all that in the act, we prepare schedules. So these schedules actually support the act. They provide procedures. They give you information over the formats, etc. Something which cannot be written in the act. Now, the first schedule deals with the mutual rights, duties of the partners, LLP and its partner. So, it is actually divided into two parts. In the first part, it deals with the mutual rights and duties of partners. Okay. It also covers the duties, the rights of LLP and partners. In my next session, I am going to discuss with you that it discusses the mutual rights and duties of the partner and partners' rights and duties towards LLP. Okay, so both of this is covered in the LLP agreement. If there's no LLP agreement, then refer the first schedule. That's like a model agreement, right, for you. There are many other schedules also. Like you have the second schedule, which provides the procedure to convert a regular partnership firm into LLP. So what is the procedure? What are the requirements? What are the documentations? Third schedule, it provides a procedure for conversion of private company into LLP. And the fourth schedule provides a procedure for conversion of an unlisted public company into LLP. Listed public company cannot be converted into LLP because the shares are already listed in the stock exchange. If you want to convert it into LLP, then you will have to unlist the shares. You will have to become an unlisted public company. Only then you will be able to convert it into a limited liability partnership. You need to memorize these schedules. They are important for exam. They are important for exam. You need to learn them. You need to learn them properly. There are actually 81 sections in the LLP Act, but section 81, okay, section number 81 is now omitted. And there are 4 schedules. Okay, there are 4 schedules. The Indian Partnership Act does not apply to LLP, something which is interesting. You have your own LLP Act. Partnership Act does not apply to LLP. Okay. The words, the expressions which are used, but they are not defined in this Act, but they are defined in the Companies Act. They will have the same meaning assigned to them in that Act. So if there are certain words, there are expressions which are used in the LLP Act, but they are not explained. However, they are defined in the Companies Act. Use the same meaning as given in the Companies Act. So that act, the word that over here indicates companies. So which act we will refer? Companies Act. The Ministry of Corporate Affairs, okay, we discussed this. Ministry of Corporate Affairs, the Registrar of Companies, they are entrusted with the task of administering the act. The central government, however, has the authority to frame the rules, the laws relating to LLP. They can also make amendments by notification in the official gazette from time to time. Okay. So we have discussed everything here. The last part. What is the need for LLP? It is the need of today's generation. Why? See, we want the best of everything. We want the best features of partnership, the best features of company. We want to do business comfortably. So this is one requirement of the contemporary business environment. It was created to meet with the contemporary growth, need of the Indian economy. It is an alternative to traditional partnership. What was the biggest drawback of our traditional partnership? Unlimited liability. Now, what was the biggest disadvantage of company? Rules, regulations, statute based governance. So we said, remove this unlimited liability of partnership. Remove the feature of statute based governance of a company. What remains are the best features of these organizations. Combine them, form LLP. So traditionally, unlimited personal liability of the partnership on one hand, then statute based governance of the company on the other hand. That is why we were demotivated. We were like, let it be. We'll do business as a proprietor only. So these were the drawbacks, but the LLP Act took care of them. It aims to enable professional expertise, entrepreneurial initiative to combine, organize, operate in an innovative, flexible, and efficient manner. Professional expertise and entrepreneurial initiative. Now, I wanted to start my business. I'm an entrepreneur. I had that initiative. I want to do business on my own. I don't want this partnership because it has unlimited liability. I don't want to incorporate a company. I don't have time for compliances. For me, LLP was a very good option. So it combines professional expertise and entrepreneurial initiative in a flexible, innovative, and efficient manner. Flexibility. We discussed earlier also. How is LLP flexible? You can frame your own partnership deed. See, I mentioned over here. There is a lot of flexibility. Yes, we have this flexibility. How is this flexibility given? It is given that you can arrive at your own mutually arrived agreement. You can frame your own agreement. It provides the benefit of limited liability but also allows the members the flexibility of organizing their internal structure through mutually arrived agreement. This is nothing but the partnership agreement, very similar to our deed, partnership deed. It is a suitable vehicle for small enterprises and for investment by venture capitalists. Why is it suitable for only small enterprise? Why not for big enterprise? Because all these big enterprises have an aim of listing their shares some or the other day on the stock exchange. So if you want to list, you have to incorporate a company. It is suitable for small scale businesses because when you do business on a large scale, the company form of business offers a lot of advantages. There are more advantages than LLP also. So if you're doing business on a big scale, company form of business is suitable. And also if you want to expand and list your shares, then obviously you will have to register it as a company or maybe convert it. So this is suitable for a small size of business. It is also suitable for investment by venture capitalists. Now, who are these venture capitalists? Have you seen Shark Tank? They are all small time, private equity investors. They will invest like 1 crore, 2 crore, 5 crore. But these venture capitalists, they invest 100 crores, 200 crores. Sometimes they come together, two or three venture capitalists, they come together. They have a huge pool of money. Okay, they have a huge pool of money. So they invest. Now, why will they be interested in investing in LLP? Why not invest in other established businesses? See, if the business is already established, what returns will you get? It is already established. It has its own set of customers. Shares are also listed. What growth can you expect in that type of organization? But if it is a small organization, you take it to a level, get it listed like Mama Earth. Shilpa Shetty was an investor in Mama Earth. So that was a very new organization. So when the organization is new, when it is small, but you see there is a lot of potential in it. You invest so you will get more than what you paid for. So she, let's say for example, paid 100 crores. Okay, she paid 100 crores. So at that time, when the company is very small, so you will get more than what you are giving. So you have given 100 crores, but in the future when the company grows, when the shares are listed, when it goes for an IPO, my investment will multiply 4 times. So she invested 100 crores. It was a new company. They invested a lot of money in advertisement, etc. Got the company to a level where they now went for IPO. Once the shares were listed, and the issue was oversubscribed, they were listed at a very good price that they started trading. Shilpa Shetty made profit of 400 crores. So her 100 crore investment is now worth 400 crore. She sold all the shares once they were listed. She sold all the shares. and then earned a profit of 300 crores. So see how these venture capitalists make a lot of money. So if you are investing in a small business, there is a lot of potential in it. Take I see IPO is one of the ways of exiting, but you can also sell this business to a bigger company like Alia Bhatt. She had her Edamama company of kids clothes, etc. There were good sales because she is a brand ambassador of her company. She took the company to a certain level, sold it to Reliance, earned profit. So see how these venture capitalists, and she was just an investor. She was not running the company on her own. There were people to do it, but she invested money, took it to a level, sold it, earned huge profit. So that is the aim. That is the work of a venture capitalist. Okay, they do help startups and small companies and basically startups. So they help startups, and that is their exit. IPO is basically their exit, or selling it to a bigger company is how these venture capitalists exit and make a lot of money. So with this, let's end. My next lecture is also actually ready. I have discussed all the definitions for you. See, I have made notes for you. I told you I will make this act very very simple for you, and this is how we have made notes. So all this I will discuss with you in my next session, but you will find that this act is now very very simple, and you will start enjoying the act. I'm very sure about that. So let me end today's session. I will see you next time. But before that, yes, I have another video wherein we discuss the official gazette notification and also the first schedule. So just have a look at that. Just get a feel of what is written in the first schedule. Once you see it practically, it'll be more relatable. And when you actually start working in your articleship, you will be having an idea of how the official gazette looks like. What is the notification in the official gazette? How does it look like, and how is it framed? What is mentioned in the first schedule? So these are additional pointers, I should say. They will add to your knowledge, and then you can flaunt all that when you start working in your article, in your firm. So let's go through that video also.